The federal court has handed down a landmark appeal decision regarding the assessment of general damages for victims of sexual harassment, increasing the damages owed to a senior employee sexually harassed by a former colleague from $18,000 to $130,000. Here to discuss this decision in detail, what it means for business, for employees, regular workplace law commentator Joydeep Hor, Managing Principal of specialist employment law firm People+CultureStrategies, joins us. Thank you so much. This a very interesting decision. Just firstly, give us the background to this and the ultimate appeal.
Yeah, so this was a decision that was handed down in February 2013. It was a sexual harassment case brought by quite a senior employee of Oracle Corporation. It was found that, yes, while she had been sexually harassed by a co-worker, that the quantum of damages that should be awarded to her should be in what was regarded at the time as being the accepted range, and it was determined to be a figure of $18,000. Now, there was nothing incorrect about the statement that $18,000 was within the range of, if you look over the history of sexual harassment cases and damages awards in Australia, it's very rare to find cases where people will have been awarded more than $25,000, $30,000. So the statement that $18,000 was within the range was absolutely right. Now, that went on appeal by the employee who had been sexually harassed, and she was appealing not the finding that she'd been sexually harassed, of course she'd won on that point, but whether the quantum that had been awarded in her favour was adequate. And the full court found that the figure was, in their words, manifestly inadequate, and revised the figure from $18,000 to $130,000. Now, that is a very significant increase. And I know that a lot of people would say that $130,000 by way of compensation, as against comparisons with other areas of law like workers' compensation or trade practices type breaches, might not be a huge amount of money. But you've got to look at it in terms of that increase, that multiplier effect, if you like, and more importantly, what that says by way of precedent. Because what the federal court has done through this appeal is they're saying, look, society's standards have changed, and while it might have been the case that an acceptable range up to now or previously was in the range of $10,000 to $20,000 to $30,000, that's just not adequate anymore. So the flow-on impact of that for employers, indeed individuals, but mostly employers, in terms of what could be the consequences for them, is very significant.
Yeah, absolutely. So, I mean, you expect this trend to continue now that this decision's come down?
Well, I think that any judge who finds that someone has been unfairly treated and finds that as a result of whether it's harassment or discrimination or victimisation, has suffered a consequence. And that was the really important issue here, that there was a finding that there had been some quite serious personal, both psychological consequences and indeed relationship consequences for this individual. And the full courts looked at the way the trial judge assessed damages and said, look, you just haven't paid appropriate attention and given appropriate weight to that. So I think what that means in the future is that in circumstances where a judge does look favourably upon an argument that is made by an employee, and when they find that they have been sexually harassed and as a result of that there's been some psychological damage, that the door has now been opened for them to make awards far more significantly than has been the case up to now. So that is quite significant.
What advice could you give to employers and employees then to minimise the risk of these issues arising in the first place?
Sure. I think it's interesting that when we reflect on this whole area of harassment and discrimination, it's not a new area. I mean, Australia has had laws dealing with these matters for the better part of the last 45 years. What we're now seeing, though, is for the first time in that 45-year history is a better alignment, I think many would say, of what the remedies are that are available to someone. And the flip side is that the consequences for someone for having done the wrong thing is a lot more real. So what that means is that employers must start taking this issue, to the extent that they don't do so currently, very seriously. They've known for some time that the brand damage associated with these claims can be powerful, that the external attention and scrutiny can be quite powerful. And now what they find is, in addition to the expense of defending these claims, you could actually face a consequence that is a lot more significant to your bottom line than might have been a worry for you up to now. Make sure that you as a business have the right policies, procedures, employees are trained. And one of the real learnings from this particular case was that the way in which the investigation was handled by the company internally was quite heavily criticised. And we're finding that when we're working with our clients on these kinds of issues at the moment, that the investigation capability within a lot of our organisations is one of the things where I think it's the biggest watch out for them. They need to think long and hard about whether that is something they should continue to do within the organisation, or whether they should bring in someone externally who's got expertise in this particular space, because this case shows that if you get it wrong, you will pay a very heavy price for that.
Just looking as well as the non-financial repercussions as well, what kinds of things could employers face that they need to be aware of as a result of a sexual harassment claim?
So most typically these things will start internally. Someone will make a complaint and there'll be some resources, often significant resources, tied up in looking into whether that complaint has any validity. There is bound to be some internal consequences through that process. People will talk, people will observe that something is going on. That will have an impact on productivity. People will form their views around who's right, who's wrong, whether there's exaggeration or whatever. That will potentially have an impact on morale. Now, that's just at the front end. At the back end, of course, if it goes to court, you've got your legal costs, the scrutiny, and a whole range of other things as well.
Joydeep Hor, really appreciate that. Thank you so much.